Hi there, everybody. Welcome back to another employment law Q&A session. My name is Chris Justice. I'm an associate lawyer with Samfiru Tumarkin. And as many of you know who've tuned in before, I'm here to hopefully answer as many questions as I can, all things related to employment law, of course. So if you've got a question regarding maybe something that's going on in the workplace, maybe you've been given a severance package, you're wondering, is this a sufficient severance package? Or perhaps you're wondering, going into a working relationship, if you've got maybe some questions about a contract, for example. Whatever it is, definitely get your questions in, and I'll do my best to answer as many as I can today. I do typically, as many of you know, like to start off by just highlighting some things that come across in my practice, some key points that I think a lot of people would need to realize and understand to protect their rights, to make sure that they, going forward, have the most options possible. This time around, I just wanted to talk about and touch on a number of key ways to figure out whether or not your severance package is fair. A lot of times people get let go, they're given a severance package. They may think it's fair, maybe because of something they read online, maybe something that they were told by their employer, or some other reason. But vast majority of the time, when I look at packages myself, based on what people come to me and bring to me, I quickly realize that the package is not fair, and that there's a lot of room still to go in terms of increasing the offer itself. So the first way to determine whether or not your severance package is fair is to make sure you understand the reason for why you were let go. You want to know, for example, if your employer is letting you go for cause or not. If it's without cause, then that's going to essentially mean that you are owed severance no matter what, and it'll just usually be a question of how much. But if your employer is alleging cause, then usually they're doing so because they think you did something wrong. They think you did something so bad that you possibly don't deserve any severance whatsoever. And so it's especially in these circumstances where there's this allegation of cause, where you're not being given any money, that you're going to want to know, especially about the reasoning for the termination. You're going to want to know the evidence. What is the company basically relying upon when letting you go for supposed cause? Are there documents that can support their position? Because it's going to be on the company to prove that they have enough to justify cause. And in some few situations, this is the case, but oftentimes when you start delving into that kind of stuff, you realize that there is no cause, or that there's no foundation for cause, there's no documentation. And then that can result not only in you getting your fair severance package, but also potentially getting more money on account of the fact that they've alleged cause and they tried to essentially get away without having to pay you a single dime. So there could be punitive damages added in many cases where companies try to allege cause but don't end up making it out. So you want to know the reason for why you're being let go. Second thing is, you want to make sure that you review any employment contracts that you may have signed in the past before your termination, because those contracts that you've signed could impact how much severance you're going to get on your way out. A lot of people may not look at the contracts they sign, whether it's at the beginning of their employment or sometime later on down the line. But in a lot of cases, there is some language in the contract that will speak to termination. It'll usually say something along the lines of, if we terminate you, this is how much we're going to give you. And usually the goal is to just give you the absolute bare minimum you're entitled to, but not your potential maximums. And so you definitely want to look at the contract. You don't want to assume, though, that just because there's some kind of language in your contract that speaks to termination, that it automatically protects the company from paying you anything more. In most cases, when I look at contracts and termination clauses, I quickly find out that they're not worded in the way that they should be, and that they don't essentially have the effect that they're intending to have, which then opens you back up to getting your full common law severance rights. So you want to make sure you go over the contract, have an employment lawyer go over the contract as well, so you know exactly what it's saying and what effect it has ultimately from the law's point of view. A third thing is, when you get a severance package, you don't want to rush to accept the offer. A lot of times there's pressure put on people to accept the package within a week or so. Don't worry about that. You do have upwards of 2 years to sue or take action against a company for more severance if you so choose. But a lot of times these deadlines and these letters, these termination letters, are put in there to essentially put you under pressure, get you to sign something. And then, you end up signing it thinking it's either a fair package or not that far off from fair. And then you realize after signing that, oh, I could have got an extra 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 months. So once you sign the release, or once you sign that severance package and you give it back to your employer, you're not going to be able to go back after that. So you definitely want to, again, talk to an employment lawyer before accepting the offer. Don't rush to accept it. As I say, you've got plenty of time if you want to take further action if things don't end up working out as they should. Another factor that people often forget is when they are let go and when they are given a severance package, a lot of times the number of weeks or the number of months that they're being offered can sometimes get into that territory of what's considered fair. But you then look into it in a bit more detail and you find out, okay, maybe they're giving me, let's say, a year of severance, but they're only paying me my base wage, or they're only giving me a year of my salary plus benefits, but they haven't mentioned anything about my bonus, my pension, maybe some stock options I have. So it's not just looking at getting your base wage and your benefits taken into consideration. You want to make sure that whatever number of months you're looking for in terms of severance, that you try to include everything you can. And a lot of times things like car allowance payments, other sorts of payments, like I mentioned before, are included or supposed to be included in the severance package. So when you add wages, salary, pension, benefits, I mean, you're talking tens of thousands of dollars extra than if you just were to look at someone's base wage and maybe their health benefits. So you want to make sure you don't leave any stone unturned, and that as many of those pieces are factored in when it comes to your severance. And last but not least, and I've sort of touched on this, you want to call an employment lawyer. You want to give us a shout. Signing off on severance is a big deal. As I say, you can't go back once you sign it. And so that's why it's very important to at least schedule a consultation with a lawyer at our firm so that we can go through and let you know, okay, is it fair? Is it not? How much more room could there be to go? And then that's going to give you a better idea as to whether or not you can maybe get more money or a substantial amount of money without even having to sue the company, whether you may need to engage in a lawsuit to get to where you kind of are aiming to go, or where you want to be. But it all starts with having that consultation, that call with the lawyer, so that you're absolutely crystal clear on what your options are, what your entitlements are, and what sort of avenues you can go down, whether it's a human rights tribunal, whether it's civil litigation, or just maybe just negotiating with your employer without having to go down that sort of road or go that distance. So those, I would say, are probably some of the main considerations, main factors to look at when it comes to determining, is my severance package fair or not. I'll get into maybe some other comments or issues I was going to touch on when it comes to the rights of older workers in the workplace, but I'm going to first go to the questions just so that I make sure I answer as many as I can. So I've got one in from Pete Chan on YouTube, who's saying that they worked at a bank for 15 years in a call center, and it affected their mental health, I assume, over the years. The doctor had asked them to give back an office role. So I assume this might have been a previous role you had before the call center role. And they were, this person was told that they're to apply for other roles internally. They have applied for many internal roles, but no success. And this 3-month job search is coming to an end, and they're worried. What are my options? And can they also decrease my salary due to accommodation? So all good questions. First of all, when it comes to accommodations, regardless of who you are, if you have, whether it's a mental health problem or a physical problem that is affecting your ability to do your job, then you should definitely consider getting the note from your doctor, getting that medical evidence, and providing that to your employer. And in terms of your accommodation request, whether it's to go off on maybe a medical leave of absence or a disability leave for a while until you're able to go back into the job you had most recently, or it could be an accommodation request where you stick with your current job, but maybe work lower number of hours, or maybe there's certain duties in your job that you can't do on account of your health. And so the accommodation request would be to say they can work, they can go back to this call center job, but here are some modifications that need to be made in order for them to do so. And as soon as the company or the employer gets that note or that medical evidence, they're going to have to do absolutely their best to accommodate your situation. As I say, whether it's to grant you a leave until you're better, or to have you continue working, but on somewhat of an accommodated basis. It may depend, Pete Chan, in your case, in terms of how the call center is affecting your mental health. What about the call center is affecting your mental health? Because if the employer can address those concerns so that you're able to do your call center job without it affecting your mental health, then that would oftentimes be a starting point. But in terms of your ability to look for other jobs, maybe jobs that you haven't had for a while, whether it's an office role or whatnot, it's going to also come back to what your doctor is asking for in terms of accommodation. And if ultimately there's no role that your doctor feels you can go back to, whether it be your call center role or whether it be just on account of there being no other alternative roles that you can go back to, then you're going to be in a situation where you may have to decide, either I go back to my call center role with maybe some accommodations, or I hope, obviously, I can continue to try to find another internal role that's different. But if the organization can prove that there aren't any other alternative roles, or that to give you another role would be too much of a change or a departure from the terms of your employment as they exist, then you may not have another role to go to other than the call center role. And the question will be whether or not you're ever able to do that call center role. So your employer may have the call center role open for you to accept, but maybe you're not ready to go back for 6 months or a year or whatnot. And they would have to hold that position open for you. So it just kind of depends, Pete Chan. But I think in this particular case, it would benefit if you give us a shout, just so we can go through the particulars, because depending on how things unfold, you might be able to get another job, you might be able to go back to your call center role, or you might be able to try to negotiate somewhat of a severance package and cut ties with the employer. As far as your question about decreasing your salary due to the accommodation, it would depend on the terms of your employment. So if you get paid by the hour, and your employer is saying, or your doctor, I should say, is saying that you can only work 3 out of the 5 days a week, then your employer is likely to only pay you for 3 out of those 5 days, because that's all your doctor's saying you can handle or that you can do at that time. If you're getting a base salary, this might be different, and you might be able to still get your full pay. Or if you are having your salary decrease due to an accommodation or a restriction you have, you might be able to then supplement whatever's left over that you're not getting paid through something like short-term disability benefits or long-term disability benefits, or there might be other benefits available for you to kind of make you whole if your employer is only paying a certain portion of your salary. So I think, Pete Chan, definitely give us a shout, because I would like to help you and just at least give you an idea of kind of what your options are going forward. I've got another question in from Ermail on Facebook, who's saying they've got a mediation to get a long-term disability. Does my opposing counsel have the right to all of my medical records? So I'll start by saying that I'm not particularly involved in a lot of STD or LTD work. But what I can say is that in a lot of these cases, when you deal with disability-related issues, employers or their lawyers try to get everything under the sun when it comes to your medical record. They try to get diagnoses, they try to get medications, prescriptions, they try to get everything, and that's not allowed. They're not entitled to everything in your medical record. They're usually only entitled to things that would speak to your limitations or your restrictions. So what is it about your circumstance that prevents you from maybe doing your job in some capacity? So they'd be entitled to know what those limitations are. They'd also be entitled to know what your prognosis is. So they would want to know if there are restrictions or limitations, how long are those going to last for? Is this something that's going to be for the rest of your life? Is this something that, you know, you might say after a year or so, I might be able to go back full time. So they'll be entitled to know, as I say, with respect to the prognosis. But generally speaking, apart from understanding what your limitations are, understanding how long your limitations are in effect, and kind of what accommodations you need, employers don't often need much more information than that. All they really should need is the bare minimum information in order to try to accommodate your illness or your disability. There may be some instances where maybe a medical record is contradicting what you're saying or what your doctor's saying, and they may want to get some more medical information to flesh out, what's true or what isn't true, or what's aligning with this or not aligning with that. So there could be some instances where opposing counsel would have the right to more medical information depending on your case. But you also want to make sure, I guess to the best you can, when you go into a mediation, that you can provide them with what you need to provide them with beforehand, so that going into the mediation, they have everything they need or that they should need to make an assessment on your file, as well as your own lawyer. And then hopefully the mediation can be more fruitful. But to blanket ask for all your medical record usually is a bit of a red flag to me. And there's got to be a very, very specific reason why they need everything as opposed to only certain pieces of information. So I would consider pushing back potentially if I was your lawyer, but you may want to have a chat with that person, he or she, in terms of their thoughts. I've got another question in from Darlene, who's asking, can your employer change your job description without notice and without a new contract to sign? The original job offer states that the description can be changed at any time. So that's a problem when it comes to contracts. They'll often, maybe not often, but a lot of times in the contract, it'll say, we reserve the right to make changes to your job at any time, whether it be wages or hours or job duty or whatever. Now, just because there might be something in the contract or the offer that says that does not give necessarily the company the automatic right to just make any changes it wants at any time without any notice. Usually, if there is something in a contract that says we reserve the right to make changes, at the very least, usually you should be being given notice of those changes. Because if, let's say, you have one job and then they come to you the next week and say, we're making significant changes to your job and it's going to start effective tomorrow, you don't really have any time to decide whether you want to agree to those changes or not. And that's kind of the point with giving notice, because at least if an employer says to you, hey, 6 months from now, 12 months from now, 2 years from now, your job's going to change and here's how it's going to change. Depending on the extent of the changes, at least you have time to consider that. Do I want to stick around here or not? Because if not, then at least that notice period you're given, however long it is, can allow you the ability to go and maybe look for another job or kind of exit that situation, as opposed to just being told on a Monday it's starting effective immediately, and now you're having to make a decision out of the blue. So I think I would want to, Darlene, I would want to look at the job offer just to see exactly what it says in terms of what can be changed, whether or not there's any implication that, of course, this all still has to be done in good faith, which is usually implied in every contract, how much notice or how little notice you were given, and what the actual changes are. So in terms of changes to job description, I mean, if you are responsible for, say, 10 things every day, and now they're coming to you saying, we're taking away 8 of those things off your plate and we're adding a different set of 8 onto your plate, that might be a lot different than if you are doing 10 things every day and they just take away 1 or 2 of those things and then replace them with something else. It may not end up affecting the job to as much of a significant degree, but there are situations where it can. And definitely before having any conversations with your employer about, yes, I'll take this new job, or no, I don't agree, give us a shout so we can at least put you in the best position in terms of making sure you communicate the right things to your employer, and then at least setting yourself up so that if something does go awry or not to your liking down the path, you'll at least have that record backing it up, and it'll give you more options in terms of what you're able to go after, whether it's severance or other sorts of damages. But thanks, Darlene, for your question. I've got another one in from B.D. on YouTube, who's saying, how long do you have to go after an employer for severance? I was let go 6 months ago, offered nothing in writing, and they just put an extra week in my account. So you have 2 years from the day you were let go if you want to start a lawsuit. It's not to say that you have to or should start a lawsuit. That's why I always like to try to negotiate packages well before that 2 years comes up. A lot of times you can get a general sense of whether or not a company will offer you more money in a matter of just maybe a couple months, give or take. So that's usually the goal from my perspective, is let's try to avoid litigation. Let's try to negotiate with them, get them to a fair severance package. If so, great. If not, and it falls apart, then at that point, consider going forward with a lawsuit if there's enough to be had there. and you're at 6 months post termination, so you've got plenty of time, I think. So I definitely think you should give us a call. Getting an extra week in your account to me seems extraordinarily low. And so it's my opinion that you're likely going to be looking at more severance. And so, yeah, give us a shout, and then hopefully we can take over and try to get you what you're owed. I've got another question in from Mick Nickel on YouTube who's saying, are labor workers entitled to severance? An employer says we don't qualify due to the nature of positions, but I'm not sure if this is true. Mick's saying that they work in 3 different provinces pretty regularly, Does that change my rights at all? Is it different if we are in a different province on a contract? It could change things. It depends on whether or not your work in all these provinces is all related and just a continuation of, say, the work you're doing in Ontario. Sometimes people may start off working in Ontario, or maybe working in Alberta, and then carry on in Ontario or carry on in Alberta. And a lot of times, if it's just a continuation of the same work, then that could be one relevant factor. You're saying as well, McNichol, that there are different contracts you may have signed with respect to the work you're doing in these 3 different provinces. That could affect things, but if it's ultimately the same company, all under the same umbrella, then you probably have a pretty strong argument to say that all of these companies are related. And, whether one's liable to pay me money or all 3 of them are liable to pay me money, I want to make sure I get what I'm owed. Being called a labor worker who's not entitled to severance, I'm not quite sure what you mean by labor worker. Most employees are entitled to severance. If you're a unionized employee, there might be a different question there, or a different situation there. But to be told you're not entitled to severance due to the nature of your position, I think I would just need to know what that nature is, because vast majority of people are still going to be owed their severance. So you definitely don't want to take their word for that. But again, like the others, McNichol, I would suggest you give us a shout so we can kind of go through things in detail. Seems like there's a lot of moving parts here, but yeah, just want to make sure that you get the proper advice moving forward. I've got another one in from Sonics on YouTube who's saying, can an employer put you on a disability if you can't perform exactly what's listed on your job description? That has to come from you and your doctor. So if you can't perform exactly what's in your job description due to a medical issue, then you should be speaking with your doctor about that, maybe getting an accommodation, or at least getting something in writing that says, this is what this person can do, this is what they can't do. And then it'll be a question of how much can you do versus not. If you can still do the majority of your job, then even if it's not everything, your employer can't often just say, well, you're going to go on a disability leave, or we're not going to pay you until you can do 100% of your job. That's not their decision to make. They can't just force you on a disability leave. All they can do is tell you if they're willing to have you work in your job with your disability, with your limitations or not. And depending on what those limitations are and what evidence you've provided to the employer to support that, their decision to either give you work or not give you work could be a violation of human rights. It could entitle you to more damages if they don't want to accommodate you. So I think a lot can flow from that. But to suggest that an employer just arbitrarily or unilaterally puts you on disability because they don't think you can do all your job, that to me seems very problematic, and is probably something you should also get in touch with us and contact us about. I've got another question in from Peppa, who's saying, am I entitled to receive my bonus from profit sharing if I was let go from my position before the end of the year payout? And yes, in most cases, you are going to still be entitled to that bonus or that profit sharing, especially if you've worked that entire year. A lot of times employers seem to think that they can get away with not paying someone their bonus or their profit share as long as they let them go before it's paid out. And a lot of times bonuses are paid out maybe in the first quarter of a given year, but the bonus itself is based on the previous year. So you could work, say, from Jan to December, bonus gets paid out in March, you're though let go in January, or maybe just before the bonus is paid out, and now you're being told you're not getting the bonus, when in reality, you've earned that bonus. You've worked that time, you've done what you needed to do, and the only thing that's now holding back is just the payout date. So a lot of times judges will look at this and simply say, this isn't fair, this is not equitable, this person is entitled to receive their profit share or bonus, even if they were let go before the payout occurred. So that could be a potentially huge amount of money that you're leaving on the table that I think people need to be aware of and definitely want to pursue if you're in a situation like that. I've got one more that'll answer a question from Jacqueline on YouTube, who's saying, that they're seeking advice regarding their employer's failure to communicate during their medical leave. I'm a 45-year-old woman recovering from a stroke and provided all necessary medical documentation. They've ignored 4 emails over 3 weeks. I want severance, and my vocational counselor has reached out as well with no response. So yeah, that's definitely a problem. I guess it depends on the situation. So you're on a medical leave of absence. You've sent 4 emails. Now I don't know what emails what information is contained in this email. I don't know if you're suggesting to them that you're trying to go back to work, to come back from a medical leave, and they're not allowing it, or if you're just simply providing them information that your status hasn't changed, that you're still going to need to continue to stay off on your leave. So I think it would depend on the emails and what it exactly is that you're asking for, Jacqueline. I would still suggest, like the others, give us a shout. Maybe we can talk about it in a bit more depth. Because like I say, if someone's on a medical leave of absence and they're sending emails saying they're ready to come back, maybe with some accommodations, and there's no response, that could be a failure to accommodate. If someone's on a leave of absence and they're simply sending their employer notes or emails just confirming that they're still going to need more time to stay off, then at least you've protected yourself in that part, and you should hopefully be given more time to improve and maybe come back. The question of whether you're owed severance or not is a tricky situation. Again, without some more information, it's hard for me to tell, but I think all the more reason to give us a shout so we can at least let you know these are all the paths you can go down, and help you make the best informed decision. But that's going to do it for my time, everyone, today. Thanks for all of those that joined. Thanks for all of those that got their questions in. Apologies for those the questions I didn't answer, but we do have this stuff going on a lot. We've got employment law Q&As going on every single week. You see down below right there. Tomorrow, in fact, at 1 o'clock with Sefton. So for those that maybe didn't get their questions answered today, tune in tomorrow at 1 o'clock Eastern. And I'm sure Sefton will do his best to answer all of your questions. But again, thanks to everyone today, and have a great rest of your Monday. All the best. Do take care.